You are rapporteur.
Yep.
Так. Іван.
Добрий день, пані Ольго.
Good afternoon, Olga. Good afternoon.
Bачите, чуєте?
Can you see and hear us? Is everything fine with your connection? Yes, thank you. I can see and hear you. The Selection Commission welcomes you at stage 2 for the selection of members of HQCJ. Your interview will be conducted by all of the members of the Commission. Let me briefly introduce them. Robert Brugeisen, me, Ivan Mishchenko, Ivan Mezintsev, Sergei Verlanov, Steven Markman, and Ted Zazhechny. The rapporteurs for your interview are my colleagues Yevhen Mezintsev and Robert Brugeisen. Should for any reason our interview be interrupted, technical issues, or an air raid alert, we will stop the interview and will resume it on a different day and at a different time. During the interview, we are kindly asking you to provide brief and precise answers, and the commissioner asking you a question has the right to limit the time of your answer. At the very beginning, you will be given an opportunity to present yourself, to tell us more about your motivation and your ideas as a potential member of HQCJ. With this, I am passing the floor to my colleagues. Robert, Yevhen, you're welcome. Thank you, Mr. Chair. Good afternoon, Olena. My name is Yevhen Mezintsev. I'm your colleague working at an appellate court. At the moment, it's a court of different specialization, but still an appellate court. Before we start with your self-presentation, let me introduce some autobiographical data, the information which can confirm that you meet the requirements of the law of Ukraine on the judiciary and status of judges for future members of HQCJ. And then I will give you the floor for introductory remarks. So, Olena Korotun was born in 1972, a judge of the Pivnichny Commercial Court of Appeal. The experience of working in the field of law is 30 years and 19 years of experience working as a judge. You graduated from the Taras Shevchenko Kyiv University. You studied at the Bar Academy. You are a doctor of law. You presented your thesis in 2009. You have a certificate proving your proficiency in the Ukrainian language. You are fluent in Ukrainian, and you received this certificate on September the 2nd of 2022. You are a lecturer at development of curriculum for the National School of Judges of Ukraine. You have quite a vast academic work. You participate in conferences and seminars. And your husband is also a judge of the Supreme Court of Ukraine. With regards to the materials on your assets, the NABU, the certificate provided by NABU to the Selection Commission, pointed to a number of assets that you have acquired over the past 20 years, but NABU does not indicate to any risks. At the same time, Olena, this doesn't mean that we will not be asking you questions about your property. We are now giving the floor to you for the introduction. Thank you. Thank you. I would like to thank the Selection Commission for this opportunity, for this honor to be a candidate for the HQCJ. I am Olena Korotun. I'm a judge of Pivnichny Commercial Court of Appeal. I've been a judge there for more than 15 years. Before that, I was working as a trial judge, and I have more than 19 years of experience working as a judge. I'm also a teacher at the Bar Academy of Ukraine, and in 2019, I received the rank of Associate Professor of the Department of International Law Practice. Since 2017, I've been working with the National School of Judges. I've worked with them in the development of trainings And as part, I was involved in the Ukrainian-Canadian project on the training of judges. I was also involved in the trainings as to the methodology for the training of candidate judges organized within the joint project of the EU and Council of Europe, consolidation of reforms in the sphere of justice of Ukraine. I am a doctor of law. In 2009, I presented my PhD thesis, so there was a mistake in the autobiography with regards to my academic career. So I've presented two theses, one in 2009 and one in 2020. So with regards to my participation in this selection, what was my motivation? The first thing is that, as you've correctly mentioned, I'm part of the judiciary and I'm interested in restoration of trust in the judiciary and the enhancement of the authority of courts and judges. And if I were to be selected as a member of HQCJ, it would be the next step in my career. I am married, as you've mentioned. I've been married for more than 30 years. I met my husband as a student, and back then nobody thought about career growth. Nobody thought that in 32 years we will be able to be proud of our family. We have two sons. Our older son is quite independent, and I believe that this marriage has been so successful because my husband and I are two independent people. We have agreed on that independence is really important in a family. Why do I believe that this position could be career growth for me? Well, it's not just about my individual career. I also want to be of use for the judiciary, because I have given all my life practically to advance this career. I was an assistant judge, I was working as part of court staff. That's why this work is the work of my life. I have some experience of working within panels of judges. I've had this experience for more than 15 years, and I've been part of different panels and collegial bodies, both at the Bar Academy, at the National School of Judges, where together with my fellow researchers, we worked on textbooks and manuals. I participated in different academic discussions. I have the immediate experience of talking to candidate judges, to interviewing them, because I was delivering lectures to them between 2013 and 2017. I talked to those candidates, and I can explain why I gave one score to one candidate and a different score to a different candidate. I have some ideas about some change should I be appointed as a member of HQCJ. I know that prior to the selection, some media outlets have published some doubts and concerns with regards to my assets and property, and I'm ready to answer these questions. Thank you. So, Olena, with regards to paperback declarations that we used to have prior to the introduction of e-declaration, which are quite different. So, in your opinion, do you think that e-declaration is a way to boost trust in the judiciary, or does it create any risks for the independence of a judge? Thank you. I understand your question. I believe it was done to enhance trust in the judiciary, for the reinforcement of the judiciary. I'm sure of that, even though I have submitted my declarations before. I'm a citizen of Ukraine, and I have filled out declarations before I was appointed as a judge. So let's have a look at those paperback declarations which you submitted some years ago. Because the people watching our selection may be having some questions. So in the declaration for the year 2011, you mentioned a gift for a sum of 38,000 hryvnias, and one of your family members, it's not indicated who, received 729,000 hryvnias. According to calculations done by our analysts, that accounted for almost $92,000. Then your husband got another gift in the amount of 50,000 hryvnias. Could you please clarify the grounds for receiving this money? Under what procedure did you and your family members get this money? Thank you for the question. My husband and I have, on numerous occasions during various selections, explained these facts. I realize that the outsiders may not be privy to this information, so let me explain. So in 2011, we declared the value of a gift under gift agreement, and this is part of my judicial dossier. It was a parking space with the value of 38,000 hryvnias, which was reflected in my declaration for the year 2011. With regards to the gift in the amount of 729,000 hryvnias, so that's a gift under gift agreement of the year 2011, my mother-in-law gifted my husband this money. And this was money of her family, and the money was transferred from the account of her husband in a bank. And in addition, we have provided all the confirming documents and the gift agreement, and the tax authorities have checked these documents because there were some questions about investment income. As far as the source of this money is confirmed, we have this proven by a statement of my mother-in-law and her deceased husband that they got this money following the sale of a house in a different country. Plus, this was also the money that they have saved. So in continuation of the topic, in 2011, you have declared income from selling real estate for 333,000 and 835,000 hryvnias. So this accounts for $345,000. So is it about the sale of the property that you've mentioned, or is it something else? No, my husband received a 3-bedroom apartment from the state. There is an order in his judicial dossier. So it's an apartment in the city of Kyiv, a 3-bedroom apartment, which we together with my husband sold for $995,000. My husband and I, while completing qualification assessment, have provided the sale and purchase agreement of this apartment, and my husband also sold a land plot in 2011, and all these gifts and sale and purchase agreements were motivated by our desire to invest in an apartment in the city of Kyiv. And that is why we sold the previous apartment and the land plot, and our in-laws helped us with buying securities, which were later used to buy the apartment. In 2010, you declared the purchase of a land plot in Kyivo-Svetoshin district with the area of 1,000 square meters. And your husband also bought a land plot in 2014 with the area of 1,200 square meters. But the value of these assets was not mentioned. Was it privatization, or how did you acquire those land plots? Thank you. Your question is clear. It was privatization. Every citizen of Ukraine, under the land code of Ukraine, has the right to get 25 acres of land for construction and some 15 acres for conducting agricultural activities. So I first acquired the land plot for agricultural activities, and then I re-registered it for construction. And he got 12 acres. It was a state program, and we used our right as any citizen of Ukraine can. Yes, that's quite clear. I just wanted to discuss the grounds for you acquiring this land plot. Your husband bought a car. We asked you about this. You have provided us with an explanation, but I do believe that we need to discuss this question again. So Mitsubishi Pajero was bought in 2013. The car was manufactured in 2007, but you did not declare the value of the car. And since 2015, when e-declarations were introduced, you started mentioning the value of the car, which was 50-something thousand hryvnias. So at the time, it was $6,250. You have provided us with an appraisal done by an expert, which proves that indeed at the moment of purchase, you also provided us with the license plate and VIN code of the car to prove that it's indeed your husband's car, and this appraisal shows that the value is indeed around 50,000 hryvnias. What draws our attention to this fact is a rather low value of this car, because as of yesterday, our analytics discovered information that there are 57 cars like this one on the market currently, manufactured around the time when your car was manufactured, and the cheapest of these cars is some 7,000 hryvnias, and the most expensive one is 18,000 hryvnias. That's why we are asking you as to whether that's the actual price your husband paid for the car, or maybe he paid some money additionally in cash. Yes, thank you. When my husband was participating in the selection to the Supreme Court of Ukraine, he has provided explanations saying that this was a gift from his mother. The appraisal was done by the expert from motor vehicle inspection. So it was a gift which was registered in the form of sale and purchase. No, it was a gift agreement. And both in the dossier of my husband and in my dossier, you can find this information. And my husband also commissioned an appraisal so that nobody has questions with regards to the value of this car. And my final question with regards to assets and property, that's a question about jewelry, a set of jewelry that you own, and a set that you have been declaring since 2015 in your e-declarations. So in particular, you have declared these two sets of jewelry without mentioning the value, the brand, or the date on which you acquired or bought these sets of jewelry. So why did you decide not to have them identified? Yes, thank you for the question. These two sets of jewelry were gifted to me by my parents. One of them was gifted by my father to my mother, and then my mother gifted it to me, and the other set was gifted to me by my father. I have never commissioned any appraisal of these jewelry sets. They are my personal things, like memorabilia. It's memory about my father, and I don't even know whether these sets have some gems in them. But I did declare them in my declaration because I believe that they are of value. As far as appraisal of jewelry sets is concerned, I was informed that it's quite pricey, and there are only several experts in Ukraine that could provide me with certificates proving the value of this jewelry. My father died quite a long time ago, and he brought these gems from another country. I don't know whether they are really pricey or not, but it's memory about him. Thank you. Let's proceed to a more theoretical aspect. So you've mentioned that you presented your thesis on the topic of intellectual property. In your opinion, this question should be quite familiar to you because you're a judge of a commercial court and you should be hearing cases on the protection of intellectual property. So there is this concept enshrined in the law on the judiciary and the status of judges about the creation of high intellectual property court, which in the future will be entrusted with this jurisdiction to hear cases on intellectual property. We have already asked this question. We'd like to hear your opinion on this issue. Do you believe that it's necessary to have this high court for intellectual property? How will it promote the investment climate in Ukraine post-war? And how justified is it in terms of workload of judges? How do you think? Thank you for the question. I support the position of those academics and lawyers who support the creation of this court. The effective law on judiciary and the status of judges does enshrine the creation of this court. As far as the number of cases and the workload is concerned, I did a small study. At the moment, we don't have many cases of this type. But in order to enhance the position of Ukraine, to improve the investment climate, I believe we need to have this court. It's us performing the requirement of our partners. And the creation of this court will improve the specialization in hearing of such cases. Let me provide you with the statistics that I have. This category of cases are heard at trial courts for more than a year. Cases with regards to intellectual property are heard by appellate courts for a year as well. If we transfer these cases for hearing of specialists who will be able to introduce some uniqueness into hearing of such cases. So if specialists are involved, then we will be able to shorten the duration of hearings. We will become more attractive for investors. The investment climate will improve. And we will be more efficient in hearing such cases, regardless of our desire as to whether we need this court or not. But I know that we have allocated only 4.5 million hryvnias in 2023 for the creation of this court. We only have an accountant and heads of staff. If we look at this realia, maybe the creation of such a court will not be a priority on day one after members of HQCJ will be created. At the same time, this is a responsibility that we have in front of our partners. We also need to remember that hearings of such cases is our image, is our reputation. If we want for our young people to be proud of their achievements, if we want for them not to be afraid to get patents, if we want to instill some level of trust in them that there is a court that can hear this type of cases, at the moment we can say that the criminal code of Ukraine contains responsibility for some types of crimes involving intellectual property. So around 6,000 cases were not heard by courts in the year 2020 alone, and only a dozen cases were transferred to courts. And what about the judgments, the verdicts? They're not there. So if the lawmakers change their attitude towards this court, saying that it's not just a court hearing commercial cases, but we also need to have the willpower of the lawmakers, saying that crimes against intellectual property should also be heard by this court. I think that if we do that, it will strengthen the position of the court, and it will strengthen the position of those judges working for this court, elevating the level of trust. Thank you. So your attitude is quite positive. Thank you very much. That's all on my side.
Thank you. Good afternoon, Olena. Sorry that I call you Olena, but Ukrainian names are always difficult to pronounce. In your motivation letter, you say, and that's a quote translated to English, so it may be badly translated. It says, of course, you can long describe the existing problems, searching for the guilty ones. But I am used asking myself, what did I do to solve them? Can you please explain what are the existing problems in the judiciary, and also what did you do to solve them?
Thank you for this question, Robert. So to answer your question, I think that the judiciary of every country has some problems, but the most pressing problem of Ukrainian judiciary and the most pressing problem for HQCJ is the completion of qualification assessment. So the qualification assessment was perceived in quite a positive way by the society, and its completion will be able to solve, maybe not to the full extent, but it will at least be a way to solve the problem of strengthening the judiciary, strengthening the trust of people in the judiciary. What was my personal contribution to solving of the issues? Well, I've been hearing court cases as a judge. As a teacher of the Bar Academy, I organize different visits for everybody willing to go to a courtroom and see how it looks like. As a trainer of the National School of Judges and a person involved in the development of curricula, I was trying, when scoring the candidates, to explain to them why their decision did not meet the requirements, or if the candidate was successful, I was also trying to motivate my scoring to them. I'm a judge of the commercial court. And during qualification assessments, sometimes we may have people who are complaining against court decisions. That's why I would like to introduce some kind of positive attitude towards people who are participating in qualification assessment or selection. Every judge should understand that they will have to go through a qualification assessment. I think that we need to maybe introduce additional questions for judges. Let's say, ask them to provide us with the best 5 judgments they've made throughout their career. For instance, I have this answer to this question. I believe that the best cases, the best decisions of a judge are the best proof of their contribution. And if you'd like me to, I can name those 5 judgments, 5 decisions.
I wouldn't know them.
So it's about a decision about the house at Podol, that's Zhukiv Island, that's a dorm room, that's the square of the Heavenly 100. That's the case of an NGO that was mentioned in my motivational letter. So this is my day-to-day work. I hear complicated cases. I work at Pivnichny Commercial Court of Appeal, which is a central district. Yes, I've had cases involving oligarchs. Maybe these are not cases about some cartels, which could be discussed here, but again, these are not small cases.
No.
As far as the scope of hearing is concerned, as far as the attention of the public is concerned. Have I answered your question? I'm sorry, Robert. Or did you mean something else by your question?
Well, in my mind, and maybe I'm wrong, the problems in the judiciary in Ukraine are not so much, let's say, the rules of the selection process, but much more 2 things. One, that there is a shortage of thousands of judges, and secondly, that there's insufficient trust in the judiciary because of irregularities and corruption. And when I read your motivation letter, I thought I'd ask you, because you say that you always think about what do I do to solve any problems that has occurred. And you have been in the judicial system for quite a long time. So you might know what you do about having not enough judges and to make sure that there will be enough judges. And I think that the selection process that has been designed by the selection process, it will take quite some time before thousands of judges will have been selected. And secondly, you have been a part of the you have been acting as a judge, and you have given many judgments, even though the trust of, for instance, the European Union, but also the people in Ukraine, the judiciary is quite low. And being part of it, maybe you can tell me what the solution to those issues are.
And that's what I'm actually answering about. I've said that the first thing we need to change is transparency. Yes, the procedures of selection really long-lasting, but that's not only for the judges to blame. The point is that the HQCJ has not been operating for more than 3 years, and the first thing that could be done today, now, to somehow quickly deal with the problem of staff shortage is, besides qualification assessment completion, would be completion of the procedures that were launched once. We already have some reserve list, and this reserve list was compiled on the basis of the selection procedures. These are assistant judges who are just waiting for the competition to be announced. What could be improved? Probably we should not wait, but we should have this ranking and give a chance to the judges to select the court to which they want to be appointed. This could be settled within 1 or 2 days. I mean that we could change the approach of the HQCJ to that. We could also develop a better methodology of judicial assessment. We could improve this methodology. We could change the tasks. I mean, we should simplify the tasks for this procedure. We could also change something about the training in the National School of Judges to postpone it for the last stage. And there are actually a lot of small things that you can change. As far as questionnaires are concerned, if we take into account the mandate of the HQCJ, I think that we need to have selection process. We should organize special vetting, and maybe we should also use artificial intelligence in the technical part of this assessment. As far as qualification exam is concerned, we should revise the methodologies. As I've mentioned, we should simplify the case fabula. We should also focus on the descriptive part of the decision, but I mean that we could probably rather shift the focus from this descriptive part in the exam towards the knowledge of the practice of the European Court. And what is most important is not the orthographics and the spelling, but the knowledge and the ability given, the opportunity given to the judge to express his opinion and to show his knowledge from the practice of the European Court. I mean that if we address the methodologies that are currently available, that have been developed, and that are applied while we are assessing the works, the papers of the candidates, we have a mathematical algorithm. But I think that we can improve this mathematical algorithm. If you mean that, I could dwell on that in great detail. If you mean my proposals and suggestions concerning lawmaking and amendments, I could tell you about this aspect. Improvement of the judiciary depends on each of us, and I think that I have generally given the answer to your question. If you want to specify something and if you want me to tell more, please just give me a prompt. What else you would like to hear?
It's a long answer, and I do not hear immediately, let's say, solutions that will work fast, I must say. Is it your view that if it is a good idea for the trust in the judiciary in Ukraine that someone would be appointed in the HQCJ who is married to a Supreme Court judge, and clearly, if I look at the asset declaration, is someone of, let's say, that someone who has a lot of assets and money? Is that something that builds trust?
Thank you for the question, Robert. I meant to tell that, and I actually started with this. In my family, both me and my husband, well, actually we got acquainted in the student years. My experience of communicating with judges and European judges shows that there are many families like this in the European community. And, well, we could take democratic countries. You didn't make conclusions like that concerning the family of Clinton, Bush. Anyway, their income and their assets are declared. I have also undergone vetting. My husband has undergone vetting. So I don't see any corruption risks here in the sense in which you are actually asking this question. But at the same time, I can tell that appointment of any candidate to the HQCJ should follow Article 24 of the Constitution in the sense that we are all equal by property status. I mean that the attitude to my property status might be the same as your attitude to the people having no assets at all. That is what my answer is in this respect.
Okay. Thank you. I will pass the floor to my colleague, Mr. Zajecny.
Judge Korotun, I'm interested in discussing with you one or two questions related to the motivation document that you filed with us. We study that very carefully, of course, and the answer to the 10 questions that we gave to all candidates. I note that you took part, as you say here, I took part in the working group in the preparation of the draft law of Ukraine on the amendments to the law of Ukraine on the judiciary and status of judges, on the implementation of judicial proceedings in the conditions of martial law, developed amendments to the procedural code. I'm someone curious about that. Can you tell me how it came to pass that you were part of this working group?
Thank you for the question. I've been a member of different task forces that had to deal with amendments of procedural codes. I joined the task force which you have mentioned, and it really was the task force working with the draft law of Ukraine on amending the law of Ukraine on the judiciary and status of judges in relation to administration of justice under martial law. And we were developing amendments to procedural codes related to the introduction of the remote justice under the martial law. I work in the respective task forces. I have been working since 2014 in such sort of groups. New Justice Project and David Vaughan addressed me as a researcher in 2014 because I presented my PhD on the notion and functions of judicial self-governance. So I actually presented the PhD thesis in 2009. As far as this task force is concerned, I was involved in its work in March 2022 because our court got a request. That was the request from the committee of the Verkhovna Rada concerning which judges could participate in the work of this task force. And since I had been a member of different task forces that had worked with procedural codes amendments, I participated in this task force. And by the way, there were 3 candidates there, but only I participated in this task force operation. Thank you.
Yes, I was simply concerned, frankly, about whether or not there was any political connection that gave rise to your appointment, and I'm satisfied from your answer that that was not the case. Turning a little bit more directly to the job, if you like, of analyzing applicants for judicial appointment, I noted your involvement, and rather long involvement, with the National School of Judges. And I'm wondering whether or not you had occasion to offer your services to score the examination portion of the HQCJ process or the practical case studies. Have you any experience in those areas?
Thank you for the question. I was involved in the work of the National School of Judges, and in the period of 2013-2018, I worked with the National School. And after the training of judicial candidates, I had to score their work. That was my job, but as far as I know, the papers actually assessed by the HQCJ members, but I was the developer of trainings. I was not developer of assignments, but I developed some trainings in the National School of Judges, and I had to assess judicial candidates. I had some communication on the scoring. What do I mean? For example, we have three trainers holding a training. I was one of the developers of this training, and I was also a trainer. Then, on the basis of this training, judges were writing judicial decisions, like at the exam of the HQCJ. And I suggested my methodology, but the High Qualification Commission approved a different methodology. It was not my methodology of assessment of scoring. And I will explain to you this mathematical algorithm. I was involved in the assessment of every candidate who passed this training. And all the papers of the candidates were divided between 3 candidates. And actually, the candidates claimed that different trainers had different assessments, and that was not very good. But let me explain that the High Qualification Commission, together with the National School of Judges, introduced the methodology which was very well grounded from the mathematical point of view, and there was a certain mathematical algorithm behind it. I think that they had to work for quite a long period of time to develop such mathematical algorithms, and the choice of the methodology was not the area of work I was involved in, but the mathematical algorithm somehow didn't work in the sense that if theoretically you understand what kind of court decision can be written, the algorithm is clear. But if the candidate, the judicial candidate, gives a different decision. I mean, for example, he does not satisfy but rejects the claim, but he motivates, he grounds his opinion, his decision. The points in the mathematical algorithms were not envisaged for that. So I wanted to have this algorithm improved, and I will suggest improving it in case I become a member of the HQCJ. In particular, the court case algorithm, well, if you, for such cases, you will have just 0 points. But I'm a teacher, I'm a lecturer, and I'm frustrated about that, because when you see that the candidate knows the law and motivates his decision, there should be some points given. That's why I would suggest some changes. We need thinking candidates, thinking judicial candidates and judges, and that will be the core principle I will try to introduce in case I'm appointed a member of the HQCJ. I can also give you some explanations concerning the National School of Judges that has really trained good candidates, and I think that more than 200 candidates are already on this reserve list. Some of them are now, some other candidates are also undergoing vetting, and I think that in the nearest future, these people will be appointed. You know, candidates had to undertake the training. The training lasted some 9 months, but they are in the status of uncertainty, and that's not possible. And the European Court of Human Rights has mentioned this in relation to the case of the judges of the Supreme Court of Ukraine against Ukraine. There can be no status of uncertainty for such a long period of time, and I think that this is the problem the HQCJ should settle on the first days of its existence. Of course, it's not only about the methodologies of judicial assessment and qualification assessment of judges and judicial candidates. Not only they have to be improved, we also need to improve the judicial questionnaire and the judicial candidate questionnaire. We should also improve the applications for the selection procedure. I have a lot of suggestions, but within the trainings of the National School of Judges, the trainer cannot actually implement this. You're just a trainer. You have to follow a certain methodology and certain type of tasks and a certain amount of time within which you can implement this program. I think that I have done my best. At least I was trying to teach the candidates the way I had been taught by the judges with whom I started my career in the position of assistant judge. Thank you.
All right, thank you for a very complete answer. There is a document that has been prepared by a former member of the HQCJ setting forth a large number of recommendations for certain changes. Considering the volume of work that the HQCJ and the members of the HQCJ will have once the HQCJ is reestablished, there is a suggestion that in order to handle that volume of work, there should be more tasks that are performed by HQCJ members that should be contracted out. In other words, there should be other participants involved, and a good example given was the scoring of the candidate exams, the preparation of the exams, the scoring of the exams, the scoring of the practical exercise could, for example, be contracted out to professors, to the high or the National School of Judges, supported, of course, financially, etc. What do you think about that idea of contracting out certain portions of the HQCJ work in order to deal with the very large volume that it is going to be facing once it has been formed again?
Thank you for the question. Well, generally, I don't object to this. I mean that there could be some assistance provided by other bodies in the implementation of parts of their tasks. But as far as your specific question is concerned, I think that we need to think it over, whether this scoring and assessment will follow some methodology, and what kind of methodology, and whether they will follow all the principles in case this task is contracted out to the trainers of the national school or to the researchers. I am accustomed to some degree of control. But then I will have a question, how do I check the results? How do I check that these functions are performed? In case the collegial joint body, and this is really about the decision of the collegial body, decides to contract this assignment out. How do we give the answer to the candidate why his score is lower than the score of some other candidate? I think that before contracting something out, we should develop the algorithm, the mechanism for that. And you know, I, as a trainee of the National School of Judges, had some doubts even concerning the previous algorithm. So in case we don't settle this problem, I think this transfer, this contracting out would be premature. And how do I openly explain it to the candidate? And you know, I always advocate openness and transparency in the work of the HQCJ concerning any procedures. And how will I explain to him that his score is, his points are lower than the score of some other candidates? Concerning lawyers with legal background, will there be no potential conflict of interest if we do this contracting out? So I think it's premature now, but I do not object in general to this principle. We could have some advisory bodies engaged in that. We should develop the approaches. For me, it's not that difficult to check such papers. Within one evening, I can actually check about 10 papers of judicial candidates. So I have my own scheme, my own algorithm. Well, if there are some changes introduced, that will probably even make it simpler. So I don't actually feel that this could be a negative experience, but I also don't think that it should be a very positive experience in terms of transparency and openness. How do I explain to the society then some lecturer, even the best lecturer, considered this paper better and this paper worse? For me, it will be a little bit problematic. But of course, we need to discuss this question, but I just don't think that now we really need to take it into account. Today, I would not phrase the problem like this. Well, the more that we have some papers that have been checked, there are some papers that are now being checked, and we also have the need for the completion of the qualification assessment of judges. And I think that here we could do some simplifications for the checking up, not to take that much time. As far as the case fabula is concerned, what kind of decision the candidate should write and what kind of decision the judge should be writing. There are two aspects here, the discretion of the commission and discretion of the lawmaker. If it is about the law, about the will of the lawmaker, and the National School of Judges has this duty, this is one thing. But you have heard my standpoint.
All right, thank you for your answers. I'm going to pass the questioning to my colleague, Judge Markman.
Judge Korotun, thank you very much for your participation in the competition. We're grateful for that. I find your motivation to be quite well done. Your experience is obviously very impressive. You're very well spoken. Your responses to a variety of questions today has been very thoughtful and intelligent. But we've got this commission here that, on behalf of Ukraine, is working hard to identify the best 16 or 32 people for recommendation to the High Council. We're trying to be responsive to the concerns of the European Union. And I at least feel that we can't make too many mistakes, if any mistakes, in this process. We really do have to do all that we can to choose the best of the best. And quite frankly, I look at the reforms of 2021, and of course that's what we're participating in today, are those reforms. And I look at the position of the Association of Judges, of which you've been a member, and I ask myself of Judge Korotun, how certain can we be that Judge Korotun is an agent of reform rather than a defender of the status quo, which needs to be changed if we're going to respond to the European Union and elevate the judiciary of Ukraine? Is she a defender of the status quo? Will she be a leader on the High Qualifications Commission, an agent of change, or a proponent of what the court has been during the 20 years or so that she's been a member of the judiciary? I hear you talking about algorithms, and, maybe I'm just not up with the times, but when I hear computer programs and algorithms as a facilitator or a vehicle of change, I'm not sure I see it that way. I think hard decisions have to be made on the High Qualifications Commission concerning which applicants should be placed on the judiciary because they're people of character and people who will enhance the judiciary. And I'm not so much enthusiastic about algorithms and computer programs or numbers coming out of the computer programs that this candidate has 38 points and someone else has 36 points. But mostly I'm concerned about the reforms of 2021. You either were part of the opposition to those reforms because you were perhaps a leader or a participant in the opposition that association brought to these reforms, or you just allowed them to become a principal opponent of reforms because you just didn't do anything. Now, I want to give you a chance because perhaps I very much misunderstand your position in 2021. I'm not saying the reforms were perfect. There are many things that you could oppose. I know many good Ukrainians are concerned about the involvement of internationals such as myself, and I understand that. But tell me something about your position on the 2020 reforms, if you would, please.
Thank you for this question. Of course, I'm positive about this reform. It is my participation in this selection that is the testimony to my positive attitude to the reform. I know that selections, in particular to the High Anti-Corruption Court, have been perceived by the EU as the first step of Ukraine towards the reform. Therefore, I do support the philosophy of those reforms, and let me tell you more, that in some of my researches and scientific articles, I even expressed the opinion, it was not in relation to Ukraine. I analyzed the experience of other countries, and I mentioned that judges in the cases on intellectual property are sometimes foreign judges. I know the experience of Kazakhstan and some other countries where foreigners were judges in the cases. I don't mean that I fully support this experience. Every issue related to the development of the judicial staff and the judicial reform has to be considered by the civil society and is considered by the civil society from the philosophical point of view of what happens later in 10, 20, or even 100 years. Every reform is judged after some time, and the reform of 2020-21 are no exceptions. Of course, I'm the leader of reform. You see my publications, you see that I was actively involved in the reform. And even the fact that I invite students to court, trying to arrange those all attendance days for them, I think that it's also a contribution to the reform. How can an incumbent judge express his or her attitude to the reform in any other way? The attitude to reform, to transparency, to openness. Well, we have some restrictions, but otherwise, I can do whatever. I do whatever I can, and my participation in the selection procedure is a bright example of that.
But wasn't the association one of the leaders in opposing reforms in 2021? And you weren't heard during that process.
Well, I've got your clarifying question. Now I'm not a member of the Association of Judges, and the association did not sign any document showing that it opposes the reform of the 2020-2021. The Association of Judges of Ukraine is the only association that has to represent judges at the Congress of the Association of Judges of Europe and at the Congress of the Associations of Judges of the world. This is right, the association that represents judges. So I was a member of it, and I was a delegate of this association at all the congresses, and I made some positive speeches on those reforms. As far as this reform and the previous reforms, and also the reforms related to other countries I know of, where the grounds for the reference letters that have been given to me by different judges who are members of European associations, I've stopped my membership in the association because my husband has been elected president of the association because of the possible conflict of interests.
Well, if you were to identify some one statement of yours or some writing or some expression of commitment to the kind of judicial reform that we're trying our best to effect here, not perfectly perhaps, but we're doing our best, we're working hard, we're trying to identify the people who are most committed to the kind of reforms that we think will allow Ukraine to pursue whatever future it decides to pursue. What might that be? What would I look to in the absence of some outspoken comments in support of reform back in 2021? What would I look to instead to be comfortable and confident that we have somebody in Judge Olena Korotun who can be counted to stand up for reform when the process gets most difficult, as it certainly will at times?
Thank you. So concerning the reform of 2020-2021, I don't have any publications of that time, but my recent article dedicated to the reform in general was the article whether we need court for professional judges. That was the article, something like this. That was published in 2012, but actually it posed the questions you have just mentioned about different virtues a judge must have. And there I posed a question, different professional issues. I was addressed because of this article by the New Justice Project. They asked me to cooperate. It was because of this article and because of the principles I expressed there supporting reform. Over the recent years, I haven't got any publications like this.
Let me ask you one other quick question, if I can. I think when most people in my country, the United States, think about intellectual property and international issues having to do with intellectual property, and they consider which countries are not very supportive and respectful of intellectual property rights, they tend to think of countries like China and Russia in particular. I'm not an expert in the subject myself, but I do have a pretty fair sense of who are seen to be the countries who are least respectful of intellectual property rights. I'm not aware of any similar thinking about Ukraine, but could you just briefly compare and contrast the approach in Ukraine with that of Russia toward intellectual property rights, copyrights, trademarks, patents, things of that sort? Is there a distinction? Is there a significant distinction? I'm quite sure there is, but could you explain it for me?
Thank you for this question. I have not studied the experience of Russia in this aspect, but I would speak positively about the English experience. And in general, with regards to intellectual property, my work dealt with administrative procedures. And what I can tell you here is that trademarks, as far as trademarks are concerned, we can apply the experience of England. If we are talking about those violations happening on the internet, because there's been this demand of the society, of the investors, and people who work with foreign investors so that we can enhance the investment climate. I'm not aware of the experience of China or Russia for that matter.
Okay, well, perhaps I caught you by surprise on that question. I thought maybe you were more deeply involved in intellectual property rights, since that was a matter of some discussion earlier. But thank you very much for your questions. I appreciate that, and thank you again for being here today. Let me turn it over to my colleague.
Дякую, пане Стівен.
Thank you, Stephen.
Пані Олена, на запитання судді Зажичного.
Olena, answering the question asked by Mr. Zazhechny, you said that in your opinion the methodology for assessing candidate judges by HQCJ should be changed. And you suggest amendments to the algorithm of the assessment. So my question is as follows. In your opinion, do we need to change the approaches towards professional training of candidate judges in view of the fact that you've been a trainer at the National School of Judges for quite a long time? Thank you. Can I please clarify your question? Do you mean professional training of a judge as part of their training at the National School of Judges? So the 2 weeks? No, it's not about judges. It's about candidate judges and their training. So you mean the year of training for candidate judges? Yes, I think that this period should be shortened. So for 3 months, we had training for assistant judges or people with required experience. And for 9 months, we had trainings for attorneys at law and those who used to work at prosecutor's office or other bodies and who had the necessary experience to participate in the competition. That's what the effective law suggests. That's what the lawmakers suggest, 1 year. In my opinion, that's too long. Why? Because these procedures must be shortened. And people who do have the relevant experience during the 9 months of training had to be dismissed or had to leave their positions to complete the training, and they were unable to get appointed after the training. Some of the competitions were not completed and people were disappointed. And only now we are coming back to the fact that we need the reserve, and these people in the reserve are good lawyers. And this long training at the National School of Judges, in my opinion, is not expedient for them. So what do I suggest? I believe that 6 months is enough. I know that in other countries the training lasts for 1 year or even 2 years. But Ukraine is not ready for that at the moment. The candidates are not ready, and the state is not ready to ensure that they are being paid while undergoing the training. Training and internship could be made shorter, and internship could be organized at a particular court where the candidate wants to be appointed. So if a candidate has already been successful in their selection, then there could be a 1-month-long internship. And should he be successful, should the person be recommended by HQCJ, that recommendation should be transferred further. So during that time, we could organize the internship. I also think that we need to improve the selection procedures in a way that we can shorten them, and that will include the training at the National School of Judges. Thank you, that's clear. I'm passing the floor to the chair, Judge Mishchenko.
Пані
Olena, in 2021, your mother acquired the right of ownership to an apartment at Tetris Hall. Could you please explain the circumstances about this acquisition, because there are some concerns about her ability to buy this kind of an apartment as far as her property status is concerned? Thank you for this question. I understand that the selection commission probably got this information from civil society organizations. But I need to tell you that any kind of information is subject to verification. This information surprised me, since my mother, and my family for that matter, never had this apartment. In 2021, my mother acquired the right of ownership to an apartment at Fedorova 1. This is a Soviet-type building built around 1980s, and I provided my explanation about this fact because I saw this information when I got access to my file. I have provided the explanation and relevant documents and agreements, and I want to explain it to the public. My mother and I had an apartment in our joint ownership, which prior to buying the apartment at Fedorova 1 was sold under a sale and purchase agreement. Both my mother and I got 570,000 hryvnias each for that sale. After that, I gifted my mother 1 million hryvnias, made up of 570,000 hryvnias that I got from the sale of the apartment, and I added some of my savings. And my mother added her share from the sale to that 1 million hryvnias, plus she had her own savings. After that, she bought the apartment at Fedorova 1 with the area of 43 square meters. And that apartment was never part of the elite complex, the Tetris Hall. Thank you. The only thing is that we got this information not from civil society organizations, not just from them. In your motivational letter, you mention, and I quote, "We will not be able to reach a new level of the development of the judiciary without the support for these changes from the inside." From the inside, you mean the support of the reform by judges? Yes, the judicial community. During these interviews, on many occasions, we have asked our candidates about the letters that different judicial associations sent to express their criticism about the judicial reform, namely the involvement of international experts because it may be seen as a violation of Ukraine's sovereignty, etc., etc. And these associations are made up of judges, many of whom are incumbent judges. So, in your opinion, do we really have this qualitative support of the reforms from the inside, from the judicial community? Yes or no? Yes, thank you for this question. Let me clarify. So, are you asking me as a member of the association or as a candidate? No, as a judge. I also think that if you are trying to change some organization, it will be very difficult to do if members of the organization, any organization, if the members don't support any change. It's much easier if the members are in favor of change. So my question is, are the judges in favor of all those changes? As incumbent judges, we are trying to give an answer on behalf of all the judges. Having my own independence, I can answer this question as a judge, and I do support the reforms, and I mentioned that in the motivational letter. 304 candidates applied for this selection, and this is also proof of them supporting the reforms. But I can tell you that any change may be initially not supported either by the society or by some judges. I think that at the beginning, the Judicial Society did not reform the qualification assessment, but then we had so many applications for the to the High Council of Justice, with people asking to become part of qualification assessment. So this is the judges already expressing a position with regards to qualification assessment. So they were not afraid to express their opinion. And I saw it during interviews of other candidates that some people may change their position with time, and this is also telling of the support of reforms. I believe that any position is positive. And the very selection is also a positive thing, as well as the position of those judges that was expressed. Even if they didn't think like that, it was still something that was support of the reform. But don't you think that the reform of the system of justice has not yet reached those goals that it has declared, and the reform has been around for quite some time? Don't you think that the reform is not that successful because it lacks the support from the inside? Well, I understand the concept of your question, but could you please clarify it? Do you mean the changes of 2020, 2021, or do you mean the reforms of the judiciary in general? I mean, at least starting from the year 2014. So you've witnessed all the changes happening in the judiciary. At least let's start with the year 2014 or the last 10 years. I can confidently tell you that the change was supported by the judicial community. And we are proud of the positive changes, the selection to the Supreme Court of Ukraine. During that selection, we have borrowed this positive practice of assessing their own judgments by judges. And you also said that maybe we haven't yet reached the goal that we have declared. And what is that end goal? Can you articulate the end goal of every reform and the means used to reach that goal? In my opinion, some tasks and some objectives were reached, and even today, the public is involved. I mean, the Public Integrity Council, civil society organizations can express their opinions, and the future HQCJ will listen to those opinions and will communicate their own position. So I think that the majority of challenges that we've had have been eliminated. Maybe yes, but as of August 2022, judges were at the bottom in the ranking of trust. It's just political parties that enjoy a lower level of trust on the side of the public. Their rating is minus 55%, while the level of trust in the judiciary is minus 46%. That's data as of August 2022. Yes, thank you. I'm using this very aspect, and I'm telling you that transparency, communication of the court judgments, of the good things that the judges are doing, should enhance this level of trust. That's why I suggested positive approach, taking into account, first of all, the experience of your commission, the one that you introduced in your selection process, to achieve the legitimate goal, the goal of enhancing trust in the judiciary and eliminating lack of that trust, as well as enhancing the authority of the judiciary. In order to enhance the level of trust in the judiciary, we need to also elevate the authority of judges. And I think it will be a priority for the future HQCJ. A quick follow-up question. As part of this large-scale reform of the judiciary, as we look at it, what were some of the failures? If we talk about the failures, then probably we were unable to complete some of the procedures for objective and subjective reasons. And I still think that we need to work on our communication with civil society organizations. PIC should be an advisory body, and we need to see civil society organizations as such that are helping us. And in case I'm appointed as an HQCJ member, I will think about a future article or paper. Thank you for expressing your remarks about my recent articles. Well, I think that the dossier should consist of a positive recommendation also. It should include a positive recommendation from the society. Sometimes judges don't speak loud enough about their cases. We don't communicate about the decisions that we are making. So if we suggest that the society provides a positive opinion about a judge, because no dossier includes this information. Yes, it's an interesting suggestion. Thank you. Dear colleagues, do we have any additional questions? Yes, if I may, Ivan. I have two quick questions for you about your family member, your son, Mykola, born in 1992. So question number one. According to the information that we've received from registries, your mother, Valentina, on May the 15th of 2021, issued a power of attorney to her grandson to achieve money, to get money as a gift. So what was the need to issue such a power of attorney? Thank you, Yevhen. I have already provided my explanation. I gifted my mother 1 million hryvnias when she was buying an apartment, and my mother is currently a pensioner. At the moment of receiving this gift, when we sold our old apartment and my mother bought a new apartment at Fedorova 1, not in Tetris Hall. So my mother, as a pensioner, was living in a village. That's why my son, her grandson, received this gift from me on behalf of my mother. He was buying that apartment at Fedorova 1, and also on behalf of my mother, he signed the sale and purchase agreement when we were selling her old apartment. That's clear, thank you. And my final question, Mykola, before the beginning of the full-scale invasion, left for Egypt, and according to the data of our Border Protection Service, he has not yet returned. Is he employed somewhere abroad? Yes, thank you for the question. Yes, we have the photos. If you don't mind, I did not include that in the explanations because you did not ask me about that. But I do have photos from our family archives. My son currently lives in Helm. He's living in Helm. So this is an article about my son and his fiancée. So Helm in Poland. No, it's the Netherlands. Yeah, I saw it wasn't written in Polish. Yes, it's the Netherlands. Since March of 2022, my son has been living in the Netherlands. He's worked at the administration of Helm, and he was invited to work in the Netherlands to work with Ukrainian refugees. And it happened so that my son and his fiancée made this decision to help Ukrainian refugees abroad. They are fluent in English, French, and that is why they were helping our refugees with documents. So they helped with receiving refugees. Yes, thank you. Thank you for the explanation. That's quite enough.
No further questions, right? Пані Олено, наша співбесіда
Olena, your interview is coming to an end.
надаємо вам можливість
We're giving you the floor
сказати те,
for some concluding remarks.
можливо, не сказали під час відповідей на
You can add some information that you were unable to tell us during answering the questions. Thank you. Thank you for the opportunity to participate in this interview. I would like to express my gratitude to the Selection Commission. Thank you for this positive selection process. I would like to tell that you have set a very friendly and positive tone within this selection. And this is something that I also support while thinking about positive ways to enhance trust in the judiciary. I think that this positive attitude towards documents, towards those decisions that everybody should be proud of, every judge should be proud of. I will take this into consideration should I be appointed as an HQCJ member. With regards to my family members, I would like to add something. I understand the questions you were asking me about the association, and let me explain. In April of 2022, my son in the city of Porto in Portugal was speaking on behalf of the head of the Association of Judges of Ukraine, his father, judge of the Supreme Court of Ukraine. And there's been many publications in the European media outlets, and the European judges were aware of that presentation. It was the meeting of the Association of Judges of Europe, during which a resolution was passed in support of the Association of Judges of Ukraine concerning addressing the war crimes of Russia. And my son prepared a presentation based on the speech of his father. And in April of 2022, that speech was presented and his active position with regards to Russian attacks. So you will be able to see pictures on the website of the Association of Judges of Ukraine. You will be able to see the photos of my son published in different European newspapers, and the resolution adopted during that meeting. And there was a volunteer present during that meeting when the resolution was supported. Thank you to the people of Ukraine for the opportunity to participate in this interview and this selection. Thank you.
На цьому співбесіда завершена.
Thank you. That's the end of your interview. Thank you for participating. Best of luck to you. Take care and goodbye.